top stories this hour. Leadership crisis in Parliament. Tonight, we're learning why the Supreme Court set aside the Speaker of Parliament's ruling to vacate some 4 seats in the legislature after the MPs in question cross-carpeted. Also tonight, we're digging down the rabbit hole as we seek answers to one key question. Tonight we ask, what are the implications? Also coming up, solemn night in memory of 2 12-year-olds who died in the ghastly East Legon accident, presumably caused by the underage son of Salifu Amwako. We're all over the stories tonight. Thank you so much for your company. If you'd like to be a part of the program beyond watching us wherever you are right now, do join us on Facebook, on YouTube, and on X, formerly Twitter. Remember to use the hashtag if you communicate with us. GhanaTonight is the hashtag to use. I'm eager to dig in our big stories tonight, but first, let's bring you a summary of some of these stories in Ghana Brief.
The Supreme Court has directed the Speaker of Parliament to halt the execution of his ruling which declared the seats of 4 members of Parliament vacant. This follows an ex-parte motion filed by the now Majority Leader Alexander Afenyomakin. The National Health Insurance Scheme will now cover free dialysis treatment for eligible patients, with those aged 18 to 60 receiving 2 free sessions each week. This announcement was made by the Minister of Health, Dr. Bernardo Koboy, during the commissioning of the Urology and Nephrology Center at the Kolebu Teaching Hospital.
If you are 60 years and above, your dialysis sessions are paid for by government through the National Health Insurance Scheme. If you are 18 years and below, that is children, all your sessions are paid for by government through the National Health Insurance Scheme. With your 8 Ghana cedi renewal of your health insurance for a year, you can have all the sessions that you need. For those 18 years to 60 years, the President of the Republic has given NHIS the go-ahead to pay for 2 sessions out of the average 4 that you receive every week.
Parents of students in second cycle institutions are incensed about the sudden change in the academic calendar. The Ghana Education Service has announced a new academic calendar for the 2024 to 2025 academic year. Per their statement, current first-year students in second cycle institutions are being promoted to their second year effective October 30.
The change has become necessary so that as a country we are able to harmonize and align our academic calendar to reverse back to the system that we used to have before. That is where, in terms of WASI, we're having students writing WASI May, June, and of course students also beginning the academic calendar in September.
In its quest to combat financing challenges associated with changing climate, the Finance Ministry has launched a climate financing division. According to Finance Minister Dr. Mohamed Amin Adam, the formation of this division contributes significantly to aligning Ghana's institutional structures to meet the requirements of the global financing landscape.
As proof of how our economic management is intrinsically linked to ecological stewardship, these dry spells prompted major economic analysts to contemplate a downward review of our economic growth. These changes reflect Ghana's demand for reform. Let me also say, ladies and gentlemen, that financing conditions have been very tight over the last 2 years, and the future is uncertain.
Ghana Brief there for you. Remember, you can be a part of the program using the hashtag GhanaTonight. But ahead of us, Supreme Court of Ghana decides against Speaker Alban Bagbin's recent ruling to expel 4 MPs from the legislature for cross-carpeting. Tonight, we're hearing the reasons behind the Apex Court's decision. More on that right now. Let's get into it. The Supreme Court of Ghana, in a shock decision, has directed the Speaker of Parliament to halt the execution of his ruling, which declares the seats of 4 members of Parliament vacant less than 24 hours after the NDC was declared the majority caucus in Parliament. The NPP caucus in the legislature took to the courts the second time, this time an attempt to ensure they do not lose their position in the chamber. Tonight, new details are emerging about the considerations made prior to the decision in the urgently heard ex-party motion, in which the court agreed with the applicants that Speaker Alban Bagbin erred. Let's go through the mind of the court as captured in that decision. I'm joined by Dennis Poberi, who has been all over this document. He's here with us to tell us what he's gleaned so far. Dennis, first tell us, we know that the Supreme Court's decision is in response to the majority side, then majority side. I'm confused about that.
It's getting complicated.
So the NPP caucus side.
Yes.
Right? The NPP caucus.
Now majority.
Now majority.
Yes.
Right. So it was in response to that. But what did they take to the courts first?
Well, I mean, their prayer was just one, and they wanted one thing from the court. And that is to say, they wanted the ruling of the Speaker to the effect that some 4 MPs vacate their seats be suspended for a maximum of 10 days. After which they said in their pleadings that they would reapply for the respondents to justify same. That means that what they were asking the court to do is for the court to stay execution of the Speaker's order for a maximum of 10 days, and thereafter they will hear, if it becomes necessary, the application will be heard on notice. But you may have heard already that what happened today was ex parte, meaning they went there without notice to the respondents. In this case, the Speaker of Parliament and whoever they thought would have been on the other side. So essentially, that was what the majority side of the House or the MPP caucus was seeking to get from the court. But the court was very magnanimous with them, gave them beyond, in fact, what they had asked for.
All of it?
Yes, all of it.
All of it.
Now, what we are understanding from the court is that this stay has actually been granted and is to last till the final case is determined.
Interesting.
Yes.
But the court also gave, many more reasons, but a couple more as to why it agreed with the applicant.
And that's important because the ex-party applications are not the normal procedure for, litigation. So the court, as a general rule, would want that the other party be given the opportunity to be heard. So it ordinarily should be on notice. But the rules, as were canvassed by the MPP caucus, were that the rules also create an exception where ex-party motions will be heard. And in that case, there has to be good reason why the court should hear that, and in the discretion of the court, same should be granted. And the MPP caucus, in making their case for this ex-party, said that if this was not granted, then in their own words, there was going to be mayhem because there was a likelihood that there will be a halt in government business.
Indeed.
They also argued that the four constituencies or the 4 MPs, the constituencies they represent, it will be a fundamental breach of the rights of those people because they will not have representations in Parliament. And of course, they also talked about the fact that they will not be able to have appropriations, and that may also affect the operations of government. Indeed, the Supreme Court, having listened to the arguments of the MPP caucus, reasoned with them. And essentially, they also agreed that if that was not granted, then essentially it will deprive the 4 constituencies that the said MPs represented. And then we know the constituencies already, and that it will deprive their basic democratic and constitutional rights of representation in Parliament until the next Parliament by the said ruling. So because of that, the Supreme Court granted that particular application. Of course, the argument was also made that the ruling will likely lead to alleged thwarting of government business in the Parliament and plunge the due management of affairs of the country into possible disruptions. The Supreme Court agreed with that, or rather, they said they appreciate the concern that was canvassed by the MPP caucus. The other issue that the court looked at was the fact that, and this was an issue that was also raised, or an argument that was made by the MPP side, to the effect that the matter in question is one that is of a constitutional interpretation. They did not think that it was within the remit of the Speaker to have interpreted the Constitution the way he did, and subsequently making that particular order or ruling which saw the MPs vacate their seats. So in that respect, the Supreme Court also agreed with them and said that, no, for that reason, let's suspend the ruling of the Speaker, and then until we hear the substantive matter as to whether or not indeed it is a matter that is for constitutional interpretation, and if indeed the Speaker did the right thing, then before that can be done.
I see.
Having looked at all these things, the court made these orders, and the orders essentially was, the first one was to the effect that the Speaker of Parliament's ruling be suspended, that the MPs whose seats were declared vacant should be recognized as members of Parliament for obvious reasons, just so you don't deny the constituents of representation in Parliament. And then also the subject matter of the suit, which they say raises questions of constitutional interpretation and application of the most fundamental and democratic rights of Ghanaians, being the right to be represented in Parliament through the elected representative. There's also an order as to how soon they have to also file their processes for the case to be heard.
Indeed.
You'd see that the court also tried to decrease the time so that it does not drag. So in essence, those were the orders that were made by the court. The biggest of them all is that the Speaker's ruling that was made yesterday is suspended. We are back to what Parliament used to be effectively.
Indeed. Thank you so much, Dennis, for bringing us those details. Dennis Poberi has just shared with us the reasons behind the Supreme Court's decision tonight. We also know that if Futu MP Alexander Apenyo-Markin, the majority leader, who also leads the NPP side in Parliament, did not hold back his excitement, perhaps to the chagrin of the NDC caucus. Take a listen. Well, you recall that, when the Speaker made that decision about some 24 hours ago in Parliament, he was quick to raise objections about the Speaker's, position on the matter. He had alluded to the fact that there was an injunction of sort on the matter, and pending his determination, the Speaker shouldn't have ruled on this. Today, a ruling went in his favor, and tonight we're hearing from him. Let's take a listen.
This is MPP. The founders of our tradition use the court to do full right. And true to it, we are Democrats. We don't believe in violence. We don't believe in mischief and unnecessary political chaos. We came to court believing that the court will do right, and indeed the court has just done that. The rights of those MPs have been reinforced, as well as the rights of those constituents who elected them. I will leave the Ghanaian public to peruse the full ruling of the court, and then the discussions can continue. But let me thank my colleagues in leadership, especially the hardworking Majority Chief Whip, for all the support, and his industry. I thank senior members of Parliament, Uncle Joe Gatti, Honorable Kennedy Japan, not the least Uncle K.T. Hammond, and others who have been supporting me. Again, equally important are my colleagues in the backbench, especially those who lost their primaries. They've been with us thick and thin. The whole of last night we didn't sleep. We've been working all night. I myself, being a practitioner of our courts, made sure we put together a solid case. And this afternoon, we've had justice. Now, those NDC people who are walking all over the place, proclaiming. If they know the law, they should now face us in the law.
We can now bring in Cletus Avoka, who is Zabila MP and former majority leader of Parliament. Good evening, Honourable. Thank you so much for joining us here. Finally, we've heard the reasons behind the decision the Supreme Court took hours ago. Do you now consider them sound?
No, not in the least. I find the reasons that the Supreme Court relied on to take this decision very, very unfortunate. It's an unfortunate development, and I don't think that the highest court of the land, the apex court of the land, should hasten to interfere into the work of Parliament with such alacrity. It's unfortunate. In my view, the Supreme Court of Ghana must be the conscience of the people, of the nation. The Supreme Court should be the conscience of the nation. In other words, the Supreme Court should not interfere into matters before Parliament with such alacrity that as it has done in this particular case. I think that the Supreme Court should be more interested in dealing with the substance of matters to be able to bring the country together, rather than to involve itself in barren legal technicalities. That is not the best for a Supreme Court. That should build the nation together.
I see.
The Supreme Court should be looking at the spirit of the Constitution. Should be looking at why Article 97, 1, G and H was passed. And the spirit of the Constitution, the spirit of that article, the Supreme Court should be more interested in that and make sure that it should try to enforce or assist those that can enforce that spirit. What is the spirit? The spirit is that sovereignty resides in the people. Power resides in the people, not an individual. So when somebody contests on a particular party ticket with ideology, with principles, with integrity, and the constituent voting based on those principles, based on those that ideology, etc., it does not lie on the MP to come to Parliament and either through inducement or fraudulent activities or promise of hope of advantage to just abandon the party at the critical period of them filing nominations to contest elections. They abandon the party in that midstream and then go and file nomination for another party.
Very well. Honourable, I'm going to have you hold the rest of your thoughts. I'll bring in now former Attorney General and stalwart of the NPP, Lawyer Ikwe Otu. Thank you so much, sir, for joining us here. This evening, we now know the reasons behind the Supreme Court's decision. Honourable Avoka, on the one hand, says, it doesn't change anything. The decision is still an unfortunate development. What are your thoughts on the reasons we've heard so far?
Well, thank you. We've all fortunately had copies of reasons now. Previously, we were relying on what journalists were reporting, but now there's a certified true copy that sets out the proceedings, including the ruling itself. First of all, I don't think that it's necessary to attack the integrity of the Supreme Court for what people call acting with alacrity. That is not the case. What happened in this matter, as your reporter explained, was that the application filed was an ex parte application. In an ex parte application, the other side is not said. So if you file an ex parte application and you are able to demonstrate that there is an agency, nothing prevents the courts from setting a date quickly and hearing it in view of the agency associated with it. So I think it's most unfair to say that the Supreme Court heard the matter with some alacrity. There's nothing much that they can do because they are dealing with an ex parte application where the other side is not also served. That's number one. Number two, you find that the orders that such ex parte applications are tracked are not final and they are not pending the final determination of the suit, but it's just for a limited period of 10 days. So what the Supreme Court said was that we have stayed execution, properly so called. It ought to be a suspended the order for just 10 days, and then they should come properly on notice to the other side and allow them to be heard. And then we go ahead, we argue the injunction properly, whether it ought to be granted or not, having heard both sides of the coin.
There are two things just before I move to Honorable Avoka. Arguments have been made that the ex parte ruling cannot be in force for more than 9 days. The Supreme Court's reasons would appear that it will be in force until a decision is taken on the substantive case. What does that tell you?
They didn't say so. They said 10 days. It will be in force.
No, the 10 days was the request that was made by the applicant. Yes. The Supreme Court didn't say the ex parte ruling should be enforced for 10 days. And it said until the case is determined.
If they did say so, if they did, I will look at it again. But the order under which they applied, which is the High Court Civil Procedural Rules, allows for ex parte applications, but the orders are only for 10 days because the other side has not been heard. So it will be unfortunate if they did not take the days into consideration. If they did not take that part of the order into consideration, it would have been unfortunate because it is limited, and then you come back and put it on notice.
Which is the argument people are making. And I want to read for you the order by the Supreme Court. What we have on our screen now is not, the first order, which is the execution of the ruling of the Right Honourable Speaker of Parliament, Alban Sumana Kingsford Bagbin, dated 17th October 2024, delivered on the floor of Parliament, declaring vacant the seats of the following members of Parliament is hereby stayed, pending the final determination of the suit. Did the Supreme Court err in that?
Yes. If they did say so, then they erred.
I see.
If they did, because the applicants themselves made it clear that they were coming under this order which allows for ex parte applications in the High Court, and usually it is only for 10 days.
Very well. I'll come back to you, Lawyer Ikweotu, but let me move on to, Honorable Avoka at this point. Yes. Honorable, your side has made the case that, listen, the Supreme Court shouldn't have even touched this matter at all because, again, like you said, it's interference of the work of Parliament. But there are those who have made the arguments that, listen, the matter in question itself is a constitutional matter, and hence the Supreme Court should look at it. What's your reaction to that?
Yes, it is a constitutional matter, and the Supreme Court can look at it. But they should look at it soberly and then diligently. If they were to do so diligently, they wouldn't have rushed into saying that the stay is going to stay until the final determination of the case. This is an interlocutory application. This is it is without notice, so the other side is not aware. So they normally take a short date, a short period, like the 10 days that apply requested for. If the Supreme Court was minded to be fair and candid on the matter, because it's a constitutional matter, they would have even given them 1 week or thereabout to be able to come by way of notice and step on the other side, so that we'll have the legal arguments or the constitutional arguments. They did not do that. But you are also aware that it is the same Supreme Court. The argument that the 4 MPs, their constituents, will be deprived of their representation and the rest of them, that doesn't hold water. In the case of James Quincy, Asim North, what happened? Was he a representative of his constituents? And he didn't even cross carpet. It is just that they said that he filed his documents late. I mean, his nationality came in late. Just that. Yet the Supreme Court injuncted him.
I see.
Months. So where's the genuineness in this? It's disingenuous. It is unfortunate that the Supreme Court, the highest court of the land, should be trying to balance issues and bring about something that will keep the nation together, rather than demonstrate this open bias. Sal is there 4 years. They were represented. Where was the Supreme Court? They shouldn't do things that will give wrong interpretation to people. And this is exactly what they have done.
I see. Honorable Avoka, again, people have argued that perhaps your side in Parliament could have chosen a better way to address this, especially when the Constitution tells us in Article 99, when it comes to issues around, the vacancies in Parliament, it should be addressed by the High Court. Perhaps your side could have explored that instead of where we are today.
No, but the method that we also adopted, Article 93 and then 18, etc., not Article clause, orders of the Standing Orders of Parliament, gave the Speaker the right to do what he did. People are referring to Article 99. Yes, I have seen it and I appreciate it. That is one way. But the Article 97 did not expressly state that this is what should be done. And Article 110 or so of the Constitution gives authority, gives the right of Parliament to use their internal mechanisms and internal rules and regulations to be able to arrive at that decision, to be able to solve the matter.
I see.
So it's neither here nor there.
Lawyer Ikweotu, that's the content of Article 99 raised questions about whether or not the Supreme Court has jurisdiction to hear the substantive matter itself.
Yes.
Well,
exactly.
You see...
no, that's for Lawyer Ikweotu.
You see, what we should not forget is that the Constitution by Article 2 and 3 says that any person who alleges that an act of any person is inconsistent with or contrary to the Constitution can always seek an interpretation from the courts. So where a matter of interpretation arises, then the proper place to go will be the Supreme Court. On the other hand, if the issues have already been determined, then you only apply the Constitution like any other law of the land. There's no need for you to go back and seek any interpretation. I give an example once where policemen were compulsorily retired at the age of 55, when the Constitution says that it should, retire at the age of 60. And then I went to court when a client of mine was compulsory retired at the age of 57, not yet 60. And then the friend said, "Are you asking me to interpret the Constitution?" I said, "No, I'm giving you rather a judgment from the Supreme Court which says that once the people are members of the public service of Ghana, they cannot be compulsory retired until they are 60. They said, "Oh, yeah. Then if that's the case, we are just going to apply the law and not to interpret." So where the law has already been interpreted, and you apply. However, in this case, you see that there has been a number of interpretations as to what the provision stands for. So it calls for an interpretation, which means that there is some ambiguity. So anybody can go to the Supreme Court to ask for, interpretation. And for example, if a parliament should pass laws by, for example, a subsidiary legislation should have to lie in parliament for 21 sitting days before it becomes a law. And then you send something there, it does not lie for that 21 days, and parliament says it has come before force. That can be challenged. That is not a procedure.
No, but should the Supreme Court be hearing the substantive case, or it should refer it to the lower court, the High Court?
No, it is a matter of interpretation. If it's a matter of interpretation and they think an issue of interpretation has arisen, they can always, in fact, remember that when there is a matter before a lower court and an issue of interpretation arises, they can refer it to the Supreme Court for interpretation. So unless we have evidence that that particular section or article has already been interpreted, then it's a matter of enforcement. So go to the proper court to go and have it, enforced. But other than that, then the issue of interpretation arises. I don't think Mr. Abuka would disagree.
I see.
There is an issue of interpretation.
Well, but Honorable Avoka disagrees with you. Honorable Avoka, you know, when I posed the question earlier, you said yes, that should be the case. That based on Article 99, the Supreme Court should not have jurisdiction over the substantive matter itself.
I have made a point already to you that if there are issues of interpretation, anytime there is issue of interpretation, even if it's right.
That's for. I was referring to Honorable Avoka.
Oh, okay. Sorry.
Honorable Avoka, go ahead.
Again to him. Yes. In my humble view, Article 97, particularly G and H, does not need interpretation. So the provisions are so clear and unambiguous that they can only be declared, like the Speaker did the declaration, the implementation. They don't need interpretation. Article 97 doesn't need Supreme Court interpretation. The provisions are so unambiguous, they are so clear and so straightforward that if you are elected on a particular party ticket and you come to Parliament and you go ahead to file your nomination to contest on a different party's ticket, then you are virtually defected or cross-carpet. And therefore, you need an application to say that you are no more a member of Parliament in the House. It doesn't need any interpretation. It doesn't need the intervention of the Supreme Court. It is not ambiguous.
Very well. Let's talk about some of the nuances that have come along with this ex parte ruling that we've heard from the Supreme Court today. Again, your side have questioned why the Supreme Court swiftly or considered this matter even urgent enough and heard it as swiftly as it did. But the Supreme Court, in its written certified copy reasons that it has written, explains why that is the case. Does it put to bed, Honorable Avoka, the debate as to whether or not the Supreme Court is biased and for that reason it is dealing with this matter so swiftly? Honorable Avoka.
Yeah, I lost you the last minute.
I was asking that your side has questioned how the Supreme Court swiftly listened to this case, swiftly catered to the demands of this case when it hasn't done that with other issues. The Supreme Court, in its written ruling, explains why this matter is urgent. Does it put to rest the debate as to whether or not the Supreme Court is biased in favor of the ruling party?
Or the Supreme Court has the ability and then the authority to urge parties to hasten up application of matters in the Supreme Court. They can give directives to the registrar to make sure the parties file their documents within a certain stipulated time so that the case can be handled. And that is very simple. Why didn't we bring that to the other cases that are also very important? That is where the issue of disingenuity comes in.
I see. Lawyer Ikweotu, I do want to also find out from you, when the Supreme Court talks about the gravity of the issue, for which reason it meets or it hears this ex parte motion, in its court, but at the same time, the person at the question of this issue, this grave issue that the Supreme Court applied some urgency to, has not been heard from. So what is the evidence that the Supreme Court relies on to be able to come to the conclusions it did in its written ruling?
Well, I believe they were all contained in the affidavit. The applicant swore an affidavit showing the urgency of the matter and the gravity of the matter. What would happen if a stay is not given? I have said elsewhere, I think these were not strategic in their moves. They were talking too much and giving too much away of all the things that they wanted to do. If you do that kind of thing, you ask the other people to sit well. And so they invited all these things onto themselves making the people rush to go and look for in order to stop what their intentions are. Now, if we say, for example, you are going to review the e-levy, the e-levy is part of the budget and the appropriations bill. If you do that, what's going to happen to funds that are allocated, budgets that are allocated through funds that will be collected from the e-levy? You're going to create confusion. You are going to reorganize all the committees of parliament and, all kinds of things that they were throwing about, were a little frightening. And that's why I say gravity of the matter and the urgency. And so you don't have to compare what has happened to whatever has been the case. For example, let's go straight to the LGBTQ. That one, there was no ex parte application. In this case, here is an ex parte application which must be heard.
Right. So
once you file it, it should be heard. It's different from a normal application or notice.
Lawyer, I'll move on to Honorable Avocat. We wrap up this conversation. What's next for your side now that this ruling has come into play?
Well, before I come there, let me allude to what my very good friend, Mr. Otu, have just said. He talked about the excitement of the NDC, the utterances they made. They have become the majority side to repeat e-levy or reduce the percentage rate of that. Is this a matter before the Supreme Court? This is not an issue before the Supreme Court. So it's irrelevant, with the greatest respect. And if you look at the conduct of the majority leader, this is a hung parliament. You get a ruling from the Supreme Court. If you think that the NDC were very excited and therefore that prompts you to go to the Supreme Court, the attitude of the majority leader, Afenyo Markins, his body language, his utterances, is not conciliatory. It doesn't build a consensus as far as Parliament is concerned.
What's next?
That's what you have said, the question you have raised. We just had the ruling today. Parliament hasn't met as a body. I mean, our caucus hasn't met as a body. Our leadership has scattered all over, including MPs, as some have gone to their consensus. It's when we congregate on Monday or Tuesday that we can then know the way forward.
I see, but is your side still holding on to the majority?
Pardon?
Is your side still holding on to being the majority?
I say that is left to my leadership, and then it's when we meet that we can take that decision.
Very well.
Just what I've been saying so far is my understanding of the issues at stake, not necessarily on behalf of the NDC side.
Very well.
So we are thinking together. So what you are saying, I was saying that when we meet on Tuesday, because Parliament has adjourned now until Tuesday morning, when we meet, or if they decide to call a meeting earlier, then we can decide and know the way forward.
Thank you so much, Honorable Cletus Avoka, Zebila MP, former Attorney General Ayikwe Otu. Thank you so much, both of you, for joining us here tonight on the news. Indeed, very interesting dynamics ahead of us as far as this conversation is concerned. But earlier, I spoke to Dr. Dominic Ayene, who is Member of Parliament for Bolgatanga East. He's also a former Deputy Attorney General on this subject matter. We looked into a number of issues, but here's a snippet of what you can expect on hot issues this week.
A very disturbing development. The reason is because, you see, for them to go ex parte, to obtain an ex parte order means that the Speaker was not on notice. Parliament was not on notice. And Parliament is just a stone throw away from the Supreme Court. And ex parte orders are an anomaly. All right? They are used to address real emergency situations where irreparable damage will be caused if there is in the, order is not obtained. All right? But in a situation where there was an attempt to serve an inter-party order, an order on notice, all right? And that service even violated the directive of the Chief Justice, which is to the effect that service on the Speaker and Parliament generally should be effected on Mondays, all right? Now, that's a Chief Justice directive that is binding on all registrars of the court and is binding on all litigants and parties. Yet the majority leader, or the former majority leader, I will continue to emphasize that the Honorable Afeyo Markins attempted to effect service on Tuesday and Wednesday. And when it was not, I mean, the service was not effected, he got frustrated, and, started throwing tantrums all over the place. Okay. Now, with this development, basically what you are doing, is to tie the hands of Mr. Speaker and Parliament. The Speaker has a role to play. So each time Speaker says something, then you run to the Supreme Court. And, the funny thing is that the Honorable Afeyo Markin was even in court before Speaker said something. All right, so he filed an injunction, to restrain Mr. Speaker in respect of matters that, that had not yet occurred, okay? Because the Honorable Haruna Iddrisu raised the issue, in a meeting in, at a rally in Tamale, okay? He quickly ran to court and
Remember, the full version of that interview live here on TV3 on Sunday at 2 p.m. Right now, let's bring you the People's Voice tonight. We'll connect with Emmanuel Samani, who's on the ground, speaking to people, seeking your views on the Supreme Court ruling.
Well, many thanks, Kamini. Good evening and welcome to the People's Voice, coming to you live from the Oxford streets of Accra. And I am Emmanuel Samani. Now, we're on the streets tonight to find out from individuals what they make of the Supreme Court's ruling, which ultimately overturns the Speakers of Parliament's decision to declare some 4 seats vacant. Now, what this means is that ultimately it resets Parliament back to the former dynamics. Now, let's get some thoughts on this this conversation. So, the Speaker of Parliament made a decision which would have meant that 4 seats would have been declared vacant. But today, the Supreme Court has overturned that decision. What do you make of it?
Well, since we all know that the Constitution is the supreme law of the land, and then the Supreme Court goes contrary to that, it makes it unconstitutional. However, they may have a specific reason why they did so. Right now, we do not have the details to tell why they actually went to overturn the ruling of the Speaker of Parliament. And we also know that the Constitution states that if an independent candidate who holds a seat in Parliament or an MP who belongs to a party leaves the party, or the independent candidate joins another party, he's supposed to vacate the seat. But right now, as it is, the Speaker of Parliament went according to the Constitution, but then the Supreme Court is going contrary to it. Like I said earlier, there may be a specific reason. So for now, we would have to wait and find out why it is so.
Right. But alongside that, what do you also make of this current Parliament in totality? What do you make of the 8th Parliament?
Well, they have their own escapades. That there are times that I would say that they are doing well, other times the opposite. But for now, I don't have much to say concerning that. I'll just wait to see how this election is going to turn out, and then know and compare to see how they've actually worked.
All right. Great. Thank you so much for your time. And there you have it, the People's Voice here coming to you live.
So that's the People's Voice with Emmanuel Samani. Thank you so much for bringing us those voices from the streets of Accra. But I want to show you some other people who have also been speaking to this matter. Let's take a look at those posts from social media. Kwame Agboja is a member of Parliament, if you are unaware. He says the Supreme Court may have to come to Parliament to enforce the bizarre ruling, which gives an indication it's going to be a very brutal Tuesday in the Supreme Court. Sami Jemfi, Communications Officer, National Communications Officer for the NDC, says it is time for positive defiance. Enough is enough. Again, making me look forward to Tuesday morning. Then it's Miracles Abuaji of the NPP, the people's majority stance. And that's all he posts on his Facebook. Perhaps we could see one last one before we wrap. Well, my understanding is that's all we have on this one. So those are some peoples as well. People who have skin in the game going on at the moment. And interesting days ahead. When we say interesting days ahead, it would appear, Tuesday will be the epitome of interesting days Interesting days ahead. Anyway, when we come back, I'll take you to that solemn event to remember those 12-year-old girls who died in that tragic accident at East Legon. I remember that this memorial is coming, but a matter of hours after the father of the underage driver and famous church leader, Bishop Salifo Amwako, released that video where he encouraged people to forgive his family. He also reached out to the family of the deceased in that video. I'll tell you more, only if you stay with us. Don't go away.
One bucket of flamingo paint is equal to several buckets of any other paint brand on the market. Flamingo paint, superior durability, superior hiding, superior coverage. Flamingo paint, simply superior. You know, one bucket of flamingo paint is equal to several buckets of any other paint brand on the market. Flamingo paint, superior durability, superior hiding, superior coverage. Flamingo paint, simply superior.
I see, Miss Yan 200 Ghana could also sister. Buy you in 5 cities and 40 Ghana. Hey, take one container your 40 to 50 pesos and not 20 Ghana. And a dancing or long can do 30 Ghana. Adai, on my bay money away.
Oh, so Casa, Michel Dean. Sha, Doctor me 20 Ghana. Ah, me pay for me 15 Ghana city a day. Omo be na ewomi ya koya na ati yesan bai
hwe enye duane bo nko an ne kosoro John Dramani Mahama time Smith 1 bag ne ye 24 Ghana cedis me nko to Smith 1 bag a yesi eye 108 cedis ayon ross ye beton ne sen it is say wo si dan a sen na wo be say John Dramani Mahama ba ma giye a ye be wo
ya nya bibia fa ho okom be kuyen yo
okom ne de enkuyen ye be fa ye ho adwen pa na MPP aban wadi ehwamo ankasa
medie minim wo haw na medie mehwe masetirem na mato ababa
ene sa na tie de a eye akufu ade ne ni ba wo mi a nyame ya dom ne se December 7 dura ye be tuo masese de YouTube
ye be tu ankasa
hwe wasetne moto abapa e de sakraya papa beba wa brabo mu to abama John Mahama ne NDC.
While the boys get front row seats to an exciting Premier League game, the girls are next door, catching up on a scenic getaway to the Australian outback. Watching together is always better. That's why DSTV Stream has content for the whole family to enjoy. Families that watch together, bond together.
If whiskey could talk, Johnny Walker Black Label would sing. With notes that only come with 12 years in a barrel. Sweet, smooth toffee, rich fruit, and a touch of smoke. Tastes as good as it sounds.
Drink responsibly, not for sale to persons under 18 years of age. Not recommended for pregnant women. This advert is FDA approved.
The luckiest.
Star 712#.
Luck is everywhere.
Hey. 8K. Hey, you get an 8K. Get packing so you have one lie. Hey, wait.
You go put it on his tab. This is my man. Good
luck. Hey, go deal with you. We are star 712. It's what you follow. I'm on dialing the magic numbers. Star 712. Now welcome to the luckiest. And now with me at home ticket. You can buy for yourself or your loved one.
Mommy, tell mommy who's here.
You're buying for me, right?
Or who else?
Oh.
Let's choose buy tickets for adults.
Love you, boo boo.
Maybe straight to option 4. Now you need to buy tickets worth 50 Ghana to qualify. Yes, you can buy random or preferred tickets. I'm choosing random tickets. That's it. Listen, if you buy the random ticket, the system chooses a random number for you. But if you buy the preferred, you get to input your own preferred 5 digits. 5.
Baby, give me your 5 numbers.
And how much are we buying?
Babe, look at the body and buy you.
With your body,
Sukume. promise.
Hey, there tread cautiously. Now follow the prompts and confirm. Now with the luckiest.
The Luckiest is regulated by the NLA on the Caritas platform, not for persons below 18 years. T&Cs apply.
The 8th edition of the prestigious Ghana Energy Awards is here. It is happening live on Friday, 25th October at the Labadi Beach Hotel in Accra. Time 6:30 p.m. prompt. Theme: the role of local content in building Ghana's energy sector. Special guest of honor: Osaberi Makwesi Atta II, the Oman Hene Ogwa traditional area. For tickets and sponsorship, call 030-3940-300. Industry partners: media partners, TV3, Graphic News Plus. Validation by Forbes Mazars Ghana. Ghana Energy Awards. 8 years of redefining excellence.
Everybody knows Acrobato. And if you know Acrobato, it means you know M-Punch Homeopathic Clinic. M-Punch Homeopathic Clinic is my pillar. Let's hear what others are saying about M-Punch Homeopathic Clinic. Who will be careful M-Punch one?
Chesena me ankasa me period na se problems wom ntina ma wo ho idea ma me papa chesena nya asem ketewa na me coin point no mo hwe me mogam no mo hwe bibia na so mo meduro me fire no ene ma won kra mienu hofro kwa na mkwan mu a eba head everything yourself
me ma me no adwodwo eda ho a wontumi nante ene ne ko end point o mama nunu a ene ne ho idea watimi asori anante.
That's end point for you of Acrobato. Hello hey ohwehwe what che okay a free bra wo di end point what dance am me call you no me Jones sema na enkoyie e person na my mre nyina na magina sebema na me be fie for there e ho na nyina jaresa. You heard everything. I have secret. M-Punch is my secret. M-Punch Homeopathic Clinic. I'm free.
Franco Trading Enterprise is still your leading mobile phones, accessories, and your electronic retail outlet. We have products such as mobile phones, television sets ranging from 24 inches to 86 inches, air conditioner from 1.5 horsepower to 2.5 horsepower. We have washing machine, refrigerators, Bluetooth speakers, CCTV cameras, and many more. For bulk purchasing and retailing, visit any of our shops nationwide or our website at www.francotrading.com. You can call the numbers on the screen for any assistance. Please note, do not pick any number apart from these numbers. Franco Trading Enterprise, still the home of quality mobile phones, accessories, and your home appliances.
Fellow countrymen and women, the desperate NPP, realizing that they are losing the 2024 elections, has once again resorted to lies to smear the nation builder, His Excellency John Dramani Mahama. The NPP's claim that Mahama was against free SHS and will cancel it when elected is nothing but a barefaced lie calculated to deceive you. John Mahama started the implementation of the progressively free SHS program in 2015 with day students and had a clear plan to expand the program to cover borders, hence cannot be said to be against free SHS. What he has been against is the poor implementation of the program. Contrary to the lies of the NPP, the next NDC Mahama government will improve the implementation of the free SHS program to make it better. We will do this by scrapping the double-track system, provide a dedicated source of funding for the program, include private SHS, improve the feeding of our children, and enhance the quality of learning outcomes. Listen to the truth from the horse's own mouth.
Free senior high school education has come to stay. If anybody tells you that I, John Dramani Mahama, son of E.A. Mahama, will abolish free SHS when I come, tell the person he's a bloody liar. What I'm against is the poor implementation of the free SHS, which is creating great inconvenience for the parents, for the students, and for the teachers.
And one of the things we'll do when we come back into office, and I know inshallah we're coming back into office, is to complete the 200 community day schools that we began, so that we can bring a quick end to the double-track system.
Beware of the NPP's lies. Vote for change. Vote for John Mahama and the NDC.
Welcome back. This is Ghana Tonight, and I'm Kemeni Amano. Tonight, the community comes together to mourn the loss of 2 young lives. A wide candle-lit vigil is underway to honor the memories of 2 12-year-old girls who died in the very ghastly accident at East Legon last Saturday. Mame Jomo Boateng and Justine Agbenu died tragically when a minor who was driving on high speed crashed into their vehicle, causing the deceased girls to burn beyond recognition. I want to take you live now to the venue for this candlelight vigil. George Queenan is there for us. George, what's happening?
It's a sad evening, a solemn one. Families, friends, loved ones, sympathizers gathered here at the scene of the incident just to, show some sort of solidarity and pay their last respect to the 2 young girls who died last week, Saturday. And there are bouquets of flowers here in their honor, candles, just name them. It's an all-white candlelight vigil in the honor of Mame Jomo Boateng and Justine Agbenu. And this actually is the spot where the incident actually happened. And so it was a minor who was driving on top speed and collided into that of the 2 other girls who had 3 other occupants, but they were able to escape. But the 2 girls, were bent beyond recognition. So the car of the minor hit their car, and their crew was forced to crash into this pole here, which had some wires on them, and so a spark fire, which burned the car of the 2 deceased. The mood here is not a good one. It's a sad one. Everyone is quite, cannot even express their words. It's not coming when you talk to them. And I'm told that the funeral of Mame Jomo Boateng will take place tomorrow at 10 a.m. at Agape at East Legon, but that of the Agbenu family are yet to formalize and put arrangements together and come up with a date for the funeral of their loved one. But let's engage some families and friends who are here for the all-white candlelight vigil. So both fathers of the deceased are old students of Achimota, and Mr. Chachu here is also an old student of Achimota, and I would like to speak to him. Mr. Chachu, what does this evening mean to you?
I wish this evening hadn't happened. It's one of those things that nobody ever, imagines would happen, and unfortunately it has happened. And I think that the key thing we all need to, put in mind is we don't want this to ever happen again. So going forward, something has to be done about the way people drive within communities. I mean, this is a residential area, and the way some people drive, it's not, it cannot be allowed, because the results of doing that is what has just happened now. And it's totally heartbreaking. And this hits closer to home than we ever thought it would.
Do you think this very incident opens up the whole conversation of good parenting?
Well, the issues of parenting obviously come to bear, because from my perspective, a 16-year-old in a Jaguar F-Pace, at that age, a young person in speed and a boy, bad mix. It's a horrible mix. And essentially this is what's going to happen. The speed at which he was moving at, even on the motorway, I haven't seen people moving that speed.
I think it's youthful exuberance, if for lack of a better word.
That's what I'm saying. As in, you don't put a 16-year-old in a vehicle that's capable of such power. Yeah. You don't mix the two, because invariably the thrill of driving something that fast would get to his head. He's not old enough to understand the implications of what could happen when you move that fast. And driving really, it's not a right. It's a privilege. You should be privileged to be driving.
Thank you so much for your time, and yeah, all the best.
All right.
Grief sweeping through aching hearts, and I just can't imagine the pains of the parents of the deceased, what they're going through right now. And I'm just putting myself in your shoes, and it's a hard one for me, and I won't even wish this for my enemy, never at all. But the latest to this development is the fact that the father of the minor, Bishop Salifa Mwako, has rendered an apology, and it waits to be seen whether or not parents of the deceased will actually accept this very apology. And they've been granted bail, the parents, 50,000 cedis, 2 sureties. And you see how things pan out. But these are live visuals from the all-white candlelight vigil here at East Legon, the very spot the incident happened.
Thank you very much, George, for bringing us that report. It looks like we have come to the end of our company tonight. So I'm so grateful for your time shared with me. But before I go, a quick reminder that Saturday morning, 7 here on TV3, Key Points will be back with Alfredo Kanse. On Sunday at 2 p.m., join me on Hot Issues when we have that extended version with former Deputy Attorney General Dr. Dominic Ayene on the Supreme Court's decision. It's always a pleasure coming your way. I'll see you same time next week. I'm Kemini Amano.
Tonight is brought to you by Flamingo Paint. Superior durability, superior hiding, superior coverage, simply superior.